Right. Welcome everyone to our event on enterprise law and the public good. My name is Iris Chu, and I'm director of the UCL Centre for Ethics and Law. And this is the research center that's bringing us the event today. We have our keynote speaker with us, Dr. Ewan McGaughey from King's College London. His discussion will be centered on his recent publication, which is a book on enterprise law and its role in governing and regulating business today in the UK. So that's here. And you can see a really large volume of blood, sweat, and tears, I believe. So Ewan will give us his keynote address for 20 minutes or so, following which I shall be inviting 4 very eminent commentators to provide their reflections on the book and what they think about the key themes and the ideologies. Our commentators are joining us from different parts of the world, and I'll briefly introduce them. We have first up Professor Elizabeth Pullman, who is Professor of Law at the University of Pennsylvania Carey Law School. Elizabeth is a highly published corporate governance and corporate lawyer in the US, and she'll be giving her reflections on Ewan's book. Following which, it will be Professor Carsten Sørensen at University of Aarhus in Denmark. Professor Sørensen is a very respected commentator on European company law, and we invited him to give his European perspective on what is covered here in terms of the UK views. Following which, we have Professor Banali Chowdhury, who is Professor of Law and Director of the Jack and May Nathanson Centre on Transnational Human Rights, Crime and Security at the Osgood Hall Law School at York University, Canada. Banali used to be here with us at UCL, and now she's back in Canada, and dealing with very cutting-edge research on business and human rights, and will be providing her perspective from that wider point of view of the company's footprint in the wider social sphere. And finally, we're inviting an industry voice. Jared Brown is chairman of NovaQuest Capital Management and of QHP Global Private Equity. He has been independent director and chairman at many corporations, and is a very respected consultant to the corporate sector. And we very much value his reflections as well on a legal academic's perspective on the role of corporations and corporate law in modern Britain. Our keynote speaker, we're very privileged to have him here with us today. Dr. Ewan McGaughey is Associate Professor at the King's College London. Today's speech will be based on his newly published book, Principles of Enterprise Law, and hopefully you'll give us an overview of your ideologies as well as your key themes and thoughts in the book and how that should shape the governance and regulation of the corporate sector in modern Britain. Over to you, Ewan.
Great. Thank you so much, Iris, for chairing and for organising. Thank you to everyone coming here. It's great to see you here in person and at home online as well. So what I'm going to be talking to you about today is enterprise law and the public good. And it's based on this enormous tome, 800 pages, I guarantee you, of non-stop entertainment and pure gold. The subtitle of the book is The Economic Constitution and Human Rights. So enterprise law is all about the finance, the governance, and the rights that we have, social and economic rights included in economic life. It's about everything from big tech corporations to energy, to how universities work, the health service, transport, and usually big enterprises are organized either as corporations or through the state. Enterprise law, I want to persuade you, accounts for the incredible growth, prosperity, and welfare that humanity has had and continues to have had since the Industrial Revolution, but also enterprise law, when it's out of balance, can result in the inhumane squalor, squander, inequality, abuse of power, pollution, climate damage, and even war that we see all around us. So enterprise law is really important for the shape of human destiny. And that's why I want to convince you that this is an important topic that we ought to be studying more fully. So my plan is in the next sort of 25 minutes or so, I'm going to outline an argument about why we don't need to do enterprise law at all, mainly coming from the University of Chicago. Secondly, I'm going to try and persuade you why we do need to understand enterprise law, why it helps us to understand our world. Thirdly, I'm going to go through what enterprise law should be doing. And part of the title of the book is the principles of enterprise law that we can identify. I'm going to focus on one in particular about the balance between the public and private side of the economy. And fourthly, I'm going to try and illustrate what enterprise law is in practice through a couple of examples. I'll start with banking and energy, or depending on how much time we have, I'll go into that in a little bit more detail. And I'm going to conclude by saying why you all really, really want this book. And it's available at all good bookstores. So that's the plan. I shall start off, as I say, with the argument about why we don't need enterprise law at all, put forward by people mainly from the University of Chicago. So those of you who are lawyers in the room already will know that in Roman law, there was this categorization, a binary divide between public law and private law. Public law was supposed to be composed of constitutional, administrative, and criminal law on the one hand, completely separate from private law, which was the law of persons, property, and obligations, and the two were supposed to be segregated. And then you had in the 20th century a US judge called Frank Easterbrook, who in a famous article called The Law of the Horse in Cyberspace, put forward an argument about why we should stick to traditional legal subjects and legal groupings like this one. We should only study at law school, he said, the general rules like property torts, commercial transactions, and not study courses that are suited to dilettantes like transport or internet law. His view was that this sort of trad law ideal was the law that illuminates the entire scope of the legal system, and we shouldn't look at all of the laws that connect to a horse, like how a horse might do damage, or contracts for sale of horses, sort of random contextual subjects. We needed big conceptual subjects to form the proper basis of a legal education. And so enterprise law definitely violates both the public-private divide, it crosses over between the two, and it definitely isn't part of this traditional legal grouping. And Frank Easterbrook also argued that we should certainly keep corporate law, which is, I suppose, part of the law of persons, away from what he ominously calls some kind of, or some form of public control. And his colleagues at the University of Chicago went even further. In the University of Chicago's theories, all parts of economic regulation were supposed to have singular purposes. So this is, again, very well known in corporate law. For instance, Milton Friedman, the famous economist, said that corporations should have one goal. There's only one social responsibility of corporations, and that's to maximize profit for shareholders. So corporate law is all about the singular goal of shareholder value. And the same game was played across the laws that animate economic life. In insolvency or bankruptcy law, Baird and Jackson argued that creditor wealth maximization should be the sole goal of insolvency. In competition law, it was all about consumer welfare. Labor law, if it existed at all, should be about the individual employee's welfare, not collective labor rights, and certainly not unions. And from all of these things, you identify one particular stakeholder. Each area of law is pursuing conflicting goals, and the public interest is completely absent. Famous article by George Stigler argues that public regulators are always captured by the businesses that they try to regulate. You can't really have any concept of the public interest. It doesn't come into any of these areas of economic regulation, and there's certainly no study of nationalized or publicly owned corporations. There's no room in this framework for different legal fields to integrate all stakeholder interests into one thing and to pursue a wider conception of the public good. But I want to make the case that enterprise law understood more broadly is important. And I'm going to give you three main reasons. First one is, if we look at this, which is the top 20 companies on the FTSE 100, we can see that a big majority of them fall under sector-specific public regulation. It's the same with the S&P 500, the DAX, whatever stock market listing you look at. So let's just take a few examples. Top one is Royal Dutch Shell. Now it's just Shell, moved its headquarters to London, dropped the Royal Dutch bit after it was sued to reduce climate emissions. But that is a company that's not just regulated by the Companies Acts, it's regulated under the Petroleum Act, for instance, of 1998, which requires it to get licenses to drill oil and gas. We've got HSBC, of course, a bank, subject to specific rules on winding up a bank if it goes insolvent under the Banking Act 2009. A bit further down the list, GlaxoSmithKline, big healthcare medicine provider. You have the National Health Service Act of 2006, which is the monopoly purchaser of GSK's products. Going down a bit to Vodafone at number 13, of course, a mobile phone company has to get a license under the Communications Act 2003. And the basic point is that if we want to understand our major corporations, we can't understand it just through corporate law and the Companies Acts alone. If we want to understand how these corporations behave, we need to bring in public regulation. So that's why we need a broader conception of enterprise law. And the second reason is that enterprise law matches how things work in real life. These are three scholars, very well known, Burley, Reiser, and Deakin, arguing for the theories behind enterprise law. So Burley, the great New Dealer, argued that corporations take their being from the reality of the underlying enterprise. Business is usually not just a single corporation, but a constellation of corporations controlled by a central holding. Reiser, German scholar, argued that governance of an enterprise includes the exercise of power, and therefore it requires legal mechanisms for its control. And the social purpose of constitutional rights and the principles of the social state are of big importance in enterprise law. Simon Deakin up in Cambridge argues that to understand the business, enterprise, or firm behavior, company law just explains a fraction of reality. So we've got to bring in more, like insolvency, employment, tort law, and arguably competition and tax to get the full picture. And enterprise law matches how government ministries or departments that regulate corporations really work. You have a Department of Education, Health, Finance, Transport, and so on in almost every country. It also matches stock market classifications. So you can't just understand corporations from corporate law alone. And the third main reason is that the concept of enterprise has already emerged in the law. So over the 20th century, we had more and more statutes right around the world that recognize the concept of enterprise. The first one was in the United States under the Fair Labor Standards Act that creates the minimum wage and the right to time and a half pay for overtime. And in the 1961 amendments, it uses the concept of enterprise to determine who is responsible for paying the minimum wage. So not just your contractual employer, but also potentially a parent company, or depending on if there's a larger, more complex organizational group, the enterprise is the one that has the duties. We have examples in the EU for public regulation, like the General Data Protection Regulation that guarantees your rights to privacy online. And there an enterprise is defined as any natural or legal person engaged in economic activity, irrespective of its legal form. And that's the key. We're looking at economic concepts, breaking free from legal strictures. And then in the UK, you have all these sort of enterprise acts, umbrella legislation that deals with things like competition, insolvency, corporate law, that's never really defined what an enterprise is, but the concept of enterprise is being used in two main ways throughout all these fields of legislation. Number one, it's being used to make sure that rights are effective, like your social rights to fair pay, or your human rights, like other human rights, like privacy, or it's being used to describe all of the elements of our economy, not just corporate law alone. So if we wanted to map out, and this is what the book does, what enterprise law could look like, this is my attempt. We have in the pyramid there what we can call the general law of enterprise. So you have in the blue on the left side of the pyramid the laws of capital. That's what corporate lawyers deal with, what pension and financial lawyers deal with. That's the equity finance going into companies. Behind that, you've got the creditor, debt capital finance, mainly regulated in the UK through the Insolvency Act. On the right-hand side, you have in the red, you have the rules that determine the rights and duties involved in labor, the investment of labor in companies, employees, unions through the Employment Rights Act, the Trade Union and Labour Relations Act. And then you've got the consumer interest, the sort of fourth side of the pyramid, which, if markets work and there's workable competition, competition generally safeguards consumer interests. But then we've got a law of specific enterprises, just like there's a general law of contract, and then lots and lots of specific areas of contract regulation. We can see lots of areas of enterprise regulation where the general law is not enough to make sure that corporations, big enterprises, act in the public interest. So we have education acts to determine your right to go to school or go to university and hopefully not pay extortionate fees. We have the National Health Service Act that organizes free public healthcare, banking acts, the Petroleum Act, the Electricity Act, the Water Industry Act, the Common Agricultural Policy, or now the Agriculture Act, and so on and so on. So in all of the sort of oases in the desert around the pyramid, you have specific enterprise laws to make sure that when the general law of enterprise fails, and particularly where competition in private enterprise fails, that enterprise still works for the public good. And that's the big thing that we really need to understand and what's missing in a lot of our legal curriculum. So you might say then, well, isn't this all really difficult? Because this is a big set of areas of law that we've now apparently got to study. And I think that you can see that it's a lot of different areas of law. And when I first started looking at this, there was sort of one different textbook for transport law or the law on the military. It took a long time to go through. But what you can identify is patterns, and that's where we get to the functions of enterprise law. So a functional approach to law means that we look for the human meaning and the human impact of law, regardless of categories and inherited traditional structures. And I think that there's three main functions that you can see in every enterprise, whether it's publicly or privately owned or governed with one group of stakeholders having voice for another. There's always three main functions that any enterprise performs. Number one, there's a finance function. Enterprises accumulate resources. They raise equity capital, debt capital, work from people's labor, money from people's custom. They can be financed by tax subsidies or by regulatory subsidies. For instance, if a company is not properly paying for pollution that it causes. You have a governance function where enterprise rules coordinate how things are produced through allocating managerial power, voting rights, regulators that have power or directors' duties. And then you've got the rights function of enterprises. Once enterprises produce things, they distribute income to workers, dividends to shareholders or to the state, and they provide goods and services to consumers or the public. And through these three functions of enterprise, we see a pattern that can explain every single one, whether it's privatized or nationalized, from the health service to rail to big tech or anything else. But so this book is arguing not just about what enterprise law is, but also about what enterprise law should be doing. And it's important to see it's taking a different approach to what we usually get in economics. I don't know if there are any economists in the room. No, but so many of you might know that what economics does is it says markets are good, but sometimes they fail. And when markets fail, we've got a case for regulation. Good statement of this is the popular book Stiglitz and Rosengart, Economics of the Public Sector, and they list sort of 5 or 6 main groups of market failure as follows. Firstly, competition can fail when you've got cartels or monopolies, or there might be a natural monopoly where it makes sense for just one enterprise to provide the service or the good. You have public goods, actually not what it sounds like, these two conditions of being non-rivalrous or non-excludable. Imagine a lighthouse, you've got boats going past, they can all enjoy the light from the lighthouse, but the lighthouse might find it hard to capture money to pay for the lighthouse services. You get an underproduction of public goods, goes the theory, so therefore the government might have a case for providing it. You've got externalities like pollution. If companies don't pay for pollution, they will overproduce the thing. So economists say, well, you've got to internalize the externality, usually with a tax, although lawyers would talk about banning things and compensation. You've got information asymmetries and incomplete markets. When people have imbalances of information that they're using to negotiate, for example. And then you've got macroeconomic failures like unemployment, inflation, and disequilibrium. Notice that the last one is a symptom rather than a cause. And I think that points to the fact that economic theory is not necessarily in the best shape that it could be. But there's a lot of things in the market failure account of an economy that are routinely understood in law, but not being used yet in economics. Economics texts don't talk about behavioral irrationality. So consumers in particular, as human beings, we often don't make rational decisions. We apply rules of thumb. We think fast instead of slow. And then there's unequal bargaining power, which is usually a big justification in labor law, tenancy, investment law, consumer protection. Unequal bargaining power comes from unequal distribution of wealth and resources. And all of these things make markets not work at their sort of production possibility frontier. But more deeply, this account from economics doesn't really make sense to many people as lawyers, because markets in law are just made up of rules of contract, property, corporations, different kinds of human rights and more. And they can be of infinite different variety. There's not one thing called the market, which then, you know, in its ideal type fails. It's profoundly nonsensical, therefore, to say that if markets fail, we should regulate them, because all markets are created by regulation. We don't regulate markets, we just alter the rules. And so the market failure account doesn't really match up with how we look at law often. So the book attempts to elaborate principles, and one of them that I'm just going to focus on, principle number 4, is how we can turn this sort of market failure approach around and talk about when competitive private enterprise actually works, what its conditions are. Principles, by the way, means identifying some kinds of tendencies or norms that we should endorse for how things should work. And the key condition that I want to suggest in the book is that private enterprise works, or it should follow, when there is a broadly equal distribution of property that is used for production, or finance used for production. Another example of a principle, principle 7, really straightforward, based on human rights, is environmental and human health should be improved and no harm allowed. So just to elaborate on the important one here, principle number 4 a bit more. This turns market failures into a positive condition, so that in order for private enterprises to work and be productive, not be wasteful, you need to have the ability for companies to start up with finance that they need, and then all the assets to compete properly. And if that condition is not fulfilled, then enterprises best put or left in the public sector or public ownership. So for instance, if you've got a natural monopoly, if you've got network effects, or you've got very unequal bargaining power, those are the classic cases where we see a high degree of public ownership. Concretely, private enterprise works by relying on banking networks, energy networks, water, transport, communications, media, marketplaces, a really interesting area of regulation. And these networks or natural monopolies are not routinely privately provided on top of education, health, housing, and security. So that's just one of 10 principles, but I'm going to spare you the other 8. And now I'm just going to move to a couple of illustrations of how enterprise law works in practice. So first of all, banking. I want to explain, first of all, the human rights that relate to banking. And I know that that doesn't sound very intuitive, that there are human rights relating to banking. And then some of the systemic failures that we see in banking and the responses, and how this maps onto the law. So first of all, banking regulation impacts, really importantly, at least 3 main sets of human rights. Firstly, the right to property or peaceful enjoyment of your possessions. For instance, if you've got your life savings in a bank account and it collapses, this is going to affect a significant human right, for instance, under the European Convention. Banking regulation and the central bank's monetary policy in particular affects the right to work. It affects the total levels of employment in society. And this is a core human right under the Universal Declaration of Human Rights, whether we actually get a job. And thirdly, there's the right to an adequate standard of living, also in the Universal Declaration, including the rights to food, clothing, housing. If these things cost too much and we can't afford them, then we're deprived from a decent livelihood, a decent standard of living. The problem is that human rights norms rarely, if ever, tell us what the best way is to realize them. So they don't tell us what the mechanics are in legislation to actually create the right to clothing or food or housing. And actually, all of these things can be very different in the way that they work in law. Human rights give us a destination, but enterprise law is the map. And banking law is heavily regulated, or banks are heavily regulated, because banking tends towards a network monopoly. And that means that the more people in a network, the more people putting deposits in a bank, the more valuable it is, the more money that the bank can lend out. So actually banks are a bit better when they're bigger. Sometimes, however, they might get too big to fail. Also, another very common market failure: customers have asymmetrical information, highly unequal bargaining power. And that's why we see in pretty much every democratic country in the world that central banks are publicly owned. Private banks are licensed by a public authority. Many countries also have a public option bank, or a large sector with cooperative non-profit banks, although not the UK, and less so in a country like the United States, but more common in other Commonwealth countries and continental Europe. Okay, so next slide might look like the PowerPoint slide from hell, but it's actually really simple despite all the detail. This is a map of the finance in the top left, the governance top right, and rights in banking law. And what I want you to focus on is the things in blue are the bits of law that come from the general law of enterprise. So if we just look in the middle, the Companies Model Articles regulations tell us that private banks, like most other companies, raise equity and debt capital on the markets, and we can see how that works through the ordinary rules in a company's constitution. But then if we want to really know how banks are financed, it's much more than that, because starting from the top, the central bank is the banker for the UK government. The Bank of England also finances private banks through its base rate, interest rate setting policy, its reserve system, its open market operations, its deposit and loan policies. There is financing tacitly through customer deposits being guaranteed by the state. There's a government guarantee against insolvent liquidation. This is all in the green in the Banking Act of 2009. So on top of the general law of enterprise, we need to understand the things in green, the specific laws of enterprise, to understand how banking really works. Moving to governance, in the blue, again, we've got the normal rules that, like in any company, bank board of directors usually is self-appointed by a governance or nominations committee, subject to a member removal right under Section 168 of the Companies Act. 50% majority can remove the board. But then again, if we really want to understand bank governance, we've got to look at the Bank of England Act, which sets up how the Bank of England is working, appointed by the Prime Minister on the Court of Directors. And then the Bank of England and the Prudential Regulation Authority licenses private banks. This is a heavy form of control to make sure that banking runs smoothly. And then you've got, in addition to different kinds of rights that exist in banking, there's a right in the consumer protection legislation against unfair or surprising terms. And there's a right against extortionate interest rates and unfair credit relationships. So that's just one illustration of how banking requires more to understand than the general law of enterprise. Now, I could talk more about energy generation. We see the same thing. Of course, this is really important to solving the climate crisis. There's human rights surrounding the benefits of scientific progress, the right to life, the right to natural resources. There's different levels in the energy sector of market failure and markets working. Huge externalities, of course. Some parts are network monopolies, some parts are much more competitive. And in general, the fossil fuel sector down in the bottom left is more monopolized, whereas renewables are much more competitive. But then in the middle, we've got these network monopolies so far as how the grid works. And if we want to understand how energy is really provided, we've got to look at the full scope of regulation in the Electricity Act, in the Petroleum Act, in the Utilities Act. So that's what we need to understand how energy really works. I'm not going to go through all of this, but that just gives you a picture. Again, the blue is the general law of enterprise, the green is specific enterprise law. Okay, so to conclude, paradoxically, number one, we cannot understand major corporations just with corporate law alone. We need the bigger picture of enterprise law. Number two, with this framework, we can better understand the empirical impact of how different enterprise laws work across different jurisdictions and social and economic outcomes. The first step is to map how things work, and then we can match what the outcomes are going to be in terms of, for instance, clean energy, full employment, affordable credit. And all of these things we are unable to do if we follow the Chicago School recommendation, which is exclude all public regulation from our general enterprise laws. And thirdly, enterprise law is just really interesting. It brings our economy alive once we start looking at sector-specific governance and finance, it brings it alive with history, with technology, and all the elements that make our society work. So we should all start teaching enterprise law in a new course. And of course, you should all get the book because it's really good. Thank you so much for listening. And I really look forward to the panel's comments.
Right. Thank you. Thank you very much, Ewan, for your very animated plea to everyone to buy into these ideas. And I agree with Ewan that this is something that is very valuable in terms of an integrative view and not an overly siloed and specialized view. Just a note to people who are online, if you have any questions, please send them through on the Q&A function, which I'll be moderating the Q&A session towards the end of this event. At the moment, we are going to invite our panelists to give their reflections on Ewan's speech as well as his book. So can I invite Elizabeth first to give your comments, please?
Yes, thanks so much. Can you see and hear me?
Yes.
Great. Well, first, heartfelt congratulations to Professor Ewan McGaughey. This is wonderful to be a part of this. Thanks to Professor Iris Chu and the event organizers. It's really an honor to be included in celebrating the book launch of this excellent work. The book is staggering in its depth and interdisciplinarity. It shares in spirit a bit of several books that I hold in high regard, ranging from Henry Hansman's The Ownership of Enterprise to Howard Zinn's A People's History of the United States. It has an underlying economic logic while often taking the perspective of a working person in society, reminding us that for much of the history of enterprise law, the relationships were those of the ruler and the ruled, the lords and the persons who were indentured, reminding us that with the wonders of the Industrial Revolution also came, quote, untold misery to masses of people who toiled in the expanding factories. And giving us the sense as readers that part of the purpose of conceptualizing an enterprise law is to encourage law in recognizing human rights as expediently as possible and to enable every member of society to realize their full potential. These are noble intellectual and practical goals. Professor McGaughey's central question is, are there principles of enterprise law, one that we can use in a practical way to understand our economic constitution today? And his central claim, as we've heard, is yes, there is a coherent enterprise law that does and can exist. And he says that enterprise law is the regulation of the finance, governance, and rights in economic life. He observes a conceptual framework that at core is asking three questions. How is an enterprise financed? Who governs it? And what rights do people have in it? And these finance, governance, and rights relate to three functions: accumulating resources, coordinating production, and distributing goods, services, or wealth. Each has an accountability mechanism resembling Albert Hirschman's exit, voice, and loyalty. And the scope of these is interdisciplinary: economics, political science, sociology, law, and more. So I'd like to highlight two aspects of this argument that I find particularly compelling, and then offer two lingering thoughts for the future of enterprise law. So first point to highlight, that enterprise law encompasses a range of topics that are too often siloed, but are necessary for understanding the life cycle and spectrum of businesses and their impact. So looking at the book, part 2, titled General Enterprise Law, includes corporate law, securities and investment law, labor rights, competition and consumers, insolvency and creditors. In the US, we have the oddity of corporate law and securities investment law being separate and somewhat overlapping bodies of law, but we think of both as business law. However, labor law, antitrust, consumer protection, and bankruptcy are typically viewed as adjacent at best. Business law is often viewed as broad enough, okay, to encompass bankruptcy, although there are often different experts in corporate and securities versus bankruptcy. Yet there is fiduciary law across both, governance that spans both, and there's surely a need to attempt to understand the interconnectedness. For example, in the US, there's been recent attempts to offload corporate liability into subsidiaries through the bankruptcy process. But Professor McGaughey goes beyond even these business law topics that can be held together under that umbrella. And bringing all of these enterprise law topics together, including for stakeholders such as employees and consumers, is somewhat of an attack or subversion to the traditional shareholder primacy and law and economics view of the corporation, which has characterized those areas as external. The value to studying them together is to have a more complete picture of regulating business and its power and impact on stakeholders. And it stands on the shoulders of some intellectual giants such as Adolf Berle, who later in his career also gave increasing attention to concentrated power, constitutional rights and protections for people against corporate power, and more. And it brings a 21st century perspective to that task, with discussions ranging from stakeholder governance of public energy companies to financing and governing internet media such as Google, Facebook, Twitter. And it highlights in particular the need for more attention on human rights in a global and connected world. Second point I'd like to highlight, it provides a useful framework in the trio of finance, governance, and rights. This recognizes, I think, observing this pattern, that financing sources ranging from public to private are highly varied and can be connected to issues of governance and rights. Personally, as a scholar and teacher of venture-backed startups, I especially appreciate this as the nature of the high-risk, high-growth entrepreneurial and innovative venture necessitates a particular form of finance that matches its features, and then this in turn drives the kind of governance and rights we see in startups. Although Professor McGaughey doesn't feature innovative startups as a particular area of specific enterprise law, he features what he calls a majority of our economic constitution. It is wide-ranging, and the framework of finance, governance, and rights is what lends coherence to the topics. At one point, he admits a skeptic might say that enterprise law is, quote, at best a work in progress, and if it's a coherent subject at all, it's deeply unprincipled. But a more optimistic view, he says, is that in law, there's a set of clear patterns of finance, governance, and rights. And that, in my view, is what ultimately ties the third part of the book together. And his other theme, that enterprise law is, quote, almost entirely about corporations and states and their use or abuse of power, is what makes part 4 cohere. So as I've established now, I'm a fan of the book. I think it's laudable that it breaks down silos and challenges the internal, external narrative of business regulation, and that it offers a coherent framework of finance, governance, and rights. So I'll conclude here with a couple thoughts that are lingering for me about the future of enterprise law. One, it's hard to believe one person knows all of the contents of this book. This is a credit to the breadth and depth of knowledge of Professor Ewan McGaughey. I wonder, though, if others, us mere mortals, can teach and stay current on enterprise law so broadly conceived. It's a challenge of the ambition of enterprise law. 2, part 3 is the part that seems potentially most subject to change. And there's a joint effort here in the US among some scholars to bring together networks and platforms and utilities that seems to have a common spirit or share in the zeitgeist of this effort. I wonder, how do we slice and dice categories of specific enterprise? Are communications distinguishable from web and broadcast media in turn from marketplaces? How do we both pull everything together as enterprise law, and then how do we determine where to make separations into specific areas of enterprise? Some areas in Professor McGaughey's book are quite related, I think, to basic societal needs or functions like education, health, energy. But it'll be interesting to see how new technologies such as AI potentially upend other areas in cycles of creative destruction or some other dynamic. The notion that we'll be able to understand it through the lens of corporate and state power, broadly construed, and finance, governance, and rights is what holds it together. It's the great contribution of this excellent book. And the notion that it's continually evolving is what makes it interesting to continue the work of studying and teaching enterprise law and its sub areas. Thanks for the opportunity to celebrate this wonderful book and author.
Thank you. Thank you so much, Elizabeth, for your resounding endorsement. Shall I now move to Carsten for your reflections, please? Carsten?
Yes. Can you all hear me?
Yes.
Great. Excellent. Also, I would like to start by congratulating Ewan on this amazing book, which has this broad scope and covers an impressive amount of materials. So I found it very interesting to read the book. Also, I think you have formulated some rather daring principles, and the fact that you have done so makes it even more interesting to read, because it gives you a certain focus, and also gives you, of course, a chance to have very clear opinions about certain matters when you stumble upon them in the different areas of law you addressed. So congratulations on this excellent book. I've been asked to say a few words about how the debate you are addressing is reflected in the ongoing debate about how to reform company law in the EU, namely how to incorporate ESG in company law, where so far we have more or less just been stuck with soft law and disclosure requirements, and now the agenda is to see whether we can move on. And this has indeed been a very controversial issue, and it has caused quite some debate, and we have very, very different positions taken here. And the point I want to address is the issue whether to move towards these principles, which I think a lot of people will agree that this is indeed the agenda. Of course, there are differences, and not everybody will agree with all your principles. But let's leave that and just say that the direction you point in is, I think, maybe not the most hotly debated issue. It's more an issue about how best to go around achieving or moving in that direction. And it seems that there is an unwillingness from a large body of people who think that this should not be addressed in company law. And of course, I guess you would certainly disagree, but I think that the issue which is worth addressing nevertheless is that maybe we cannot expect all 10 principles to be incorporated and be fully functional in company law. We also need to think that company law is not, well, it's just a part of this huge body of law which you call enterprise law, and even part of an even bigger body of law, which include, for instance, environmental law and climate law and other areas of law. And the problem, or the challenge, is then to decide how much should we put into company law to make it work, or can we just rely on the fact that the whole body of law will balance these different laws and these different aims, and then we could, given the right mix of these law, we could achieve the same without actually incorporated the principle in each single act, including the Companies Act. So I can see that if we included all these 10 principles in the Company Act, we would definitely have a lot of problem, because it would be certainly be blurring and making the company law somewhat more unfocused. At least I think a lot of people would argue that, and also we would create a lot of enforcement problem, because the mechanism we have at the moment in company law will not be sufficient on its own to enforce such principle. Also, companies differ very much, and therefore, since it is one of the general enterprise law, we should maybe be more careful compared to the more sector-specific legislation you addressed there. I think it's more fair to say that here we have a more coherent body of enterprises, and we can find the right mix and balance there. So my question or proposal to you would be that it might be sufficient that we are making sure that company law is at least enabling the enforcement of these other laws, other enterprise law, and I'm not sure whether you would include in environmental law and climate regulation in that body of laws, but at least that the company law should be open to that. So we should ensure that the duty of directors does not singularly point towards the interest of shareholders, for instance, but it should also, of course, be open to other interests. And I think that would be the case in most countries anyways, because well, corporate directors will have a duty, of course, also to observe other types of law than company law, even though company law, of course, for them may have a special position. They will also need to observe environmental law, and if they don't, the company might be stopped or it might be fined, and this will have consequences, and in the end it will have consequences for the directors as well. So we have to make sure that of course the company law is open and facilitates these other laws, for instance by including procedures which makes everybody aware that there are other obligations than those expressly found in company law, but which are also, of course, part of what the directors should pursue. So you made the argument there that the classic point of view in Chicago School was that these different laws should have one goal only, and I'm not arguing for that. But on the other hand, I'm also arguing that not every law should have these very diverse and manifold goal that you are formulating for environmental law. It might be enough that the mix is achieving that, and also, of course, I could mention the ongoing debate about the due diligence directive, which I think is actually also interesting because it points towards the problem I just mentioned. Because the most controversial part of that proposal is the duties of directors found in Article 25 and 26, which the Council has now just suggested to abandon. And the reason why they did so was that it interfered too much with core company law, and they couldn't, well, at least the member states or the majority of the member states couldn't really accept that kind of interference in core company law, or maybe they just couldn't see the full consequences of it. Of course, it has been argued that it is tricky to enter such foreign elements. Whether that's true or not, I'm not sure I agree, but at least I would say that if they adopt the rest of the directive and adopt the due diligence duties, I don't think that the directors will have any other choice than, of course, also to take these duties serious, and therefore it will naturally, by combining different laws, because the due diligence directive is not going to be a company law directive, and thus will not need to be incorporated in company law. So the mix of the two will also affect how company law will work, but it will not be in company law. It will be in a separate law, I guess. So, and of course, another interesting point is, of course, that now it's very much debated whether the banks should be included again. At least the take from the Council is that the member states should be allowed not to include banks in the directive and the due diligence duties. And of course, this is also pointing, I guess, to, well, underlining a point you also make in the book, that banks are not always in for the full set of duties that other sectors are, and it makes, again, maybe a good case for showing that banks consider themselves to be a special case. I would like to hear, if you have the time to discuss, I would like to hear your opinion about whether you agree that the mix should be enough, and therefore we should not go all in for incorporating the 10 principles in each and every part of the enterprise law legislation. And with that, I think I'll end my intervention and again, congratulate you on the book.
Thank you very much, Carsten. I mean, the whole point of this event is to basically bring all the debate together so that not just the speakers, but also panelists from different points of view will be able to give their reflections on what is really the role of corporate law today. I will now call on Professor Banali Chowdhury. Banali, would you like to provide your reflections? Thank you, Banali.
Yeah, so thank you very much to the organizers, and a special thanks to Iris for including me in this event. I am delighted to be part of Ewan's marketing strategy today and to be speaking about his book on the principles of enterprise law. Now, this book is clearly a magnum opus, and I've only been given a very short amount of time. And so I'm only going to briefly look at this book through my lens of specialty, which is business and human rights. Now, this book really offers a very unique central premise, and that is that the goal of enterprise law is social justice. And as the book notes, that modern enterprise, which is most often organized in corporations, it gives us the ability to live a life of splendor and holds the promise of a future free from poverty. But when it's out of balance, then enterprise law can also account for inhuman levels of squander, abuse of power, and exploitation. And so, as a way to ensure that the promise of enterprise law is not outdone by its ability to harm, Ewan uses social justice as a framing device. And social justice is, as he notes, not corrective or distributive justice, but rather it expands human capacity, it frees human creativity, and creates direct available opportunity so that the opportunity to develop individuality becomes fully actualized. And to ensure that social justice truly becomes the end goal, the book proposes 10 principles of enterprise law. And now, again, because of my very limited time, I'm only going to focus on 2 of these 10 principles. The first principle, which I thought was really of relevance, is that environmental and human health should be improved and that no harm should be allowed. And the second is that enterprise law should enable every member of society to realize their full potential. Now, from a business and human rights lens, these 2 principles are crucial because they outline the baseline requirements that the international community asks of corporations. So this first ask is that corporations not harm human rights and the environment, or what is known as a negative obligation. And the second, and this one is a bit more contentious, and that is that corporations at least contribute to the positive realization of human rights. Now, Ewan takes up these 2 propositions to some extent in a chapter that's called Natural Resources. And in that chapter, he explores the relationship between corporations and what is arguably one of the most important human rights today, and that is the right to a healthy environment. Now, the right to a clean, healthy, and sustainable environment is actually a relatively recently recognized human rights. It's only in July 2022 that the United Nations finally recognized this right. And prior to this time, many had believed that environmental and human rights were 2 separate issues. But today, the international community recognizes not only that we have a universal right to a healthy environment, but that climate change poses one of the most significant threats to humanity. And the book does an amazing job at exploring the challenges posed by climate change. So some of the interesting stats that I found from this book, which I really enjoyed, were that 3 of the top 11 FTSE 100 companies are natural resource companies. The British Coal Corporation has been responsible for 1.13% of the whole world's greenhouse gas emissions from 1751 to 2016. And just 90 companies are responsible for around 63% of all greenhouse gas emissions. And as Ewan writes, with profit comes responsibility. And certainly corporations have profited from the ensuing destruction of the planet. So what do we do about this? Well, Ewan covers this interesting idea about using the courts or litigation as a type of regulator for corporations in relation to climate change issues. So he discusses the Luia and RWE decision in which the German courts are assessing whether the German corporation RWE is responsible for climate change damage to a glacier in Peru. Now, the German courts are currently determining if RWE is responsible for global carbon emissions. And if they do, or if they find this liability, this could actually translate into the company being partially responsible for the effects of those emissions to a glacier in Peru. So effectively, this case could establish climate damage liability for corporations, no matter where the effects are felt. And this could lead, as Ewan notes, and somewhat joyfully, I suspect, that this could lead to wide-scale insolvency for fossil fuel companies. Now, he also describes that the Dutch courts have found a fossil fuel company liable in tort for their failure to abide by the Paris Agreement. So that decision is the Friends of the Earth and the Royal Dutch Shell, in which the Dutch court reasoned that climate change posed a threat to human rights of Dutch residents, meaning that Shell should be liable for its contribution to this threat. And finally, he looks to the UK's Company Act as a source of regulatory litigation in this area as well. So he posits that a director's failure to consider climate change could be a breach of Section 174, or the duty of reasonable care, skill, and diligence. And he draws from a pig farming case in which he argues that directors would be responsible for failing to save the costs that are associated with acting more environmentally, such as by reducing energy bills. And this is certainly a novel argument, and I work in this area and I've never heard this one before. And to some extent, it's actually being taken up in a British court right now. So Client Earth, which is a NGO in the UK, is currently bringing an action against Shell for its climate change harm, although it's not arguing a breach of Section 174, it's arguing a breach of Section 172. But clearly, they obviously took some tips from Ewan's book. So all this goes to say, it raises the question as to whether enterprise law should be viewed by reference to the two principles that Ewan has set out. And I would have to agree and say that yes, that the law should prevent enterprises of all types from engaging in human rights and environmental harms. And the natural resources chapter gives lots of more examples of that. I think we are currently at the state where we simply cannot allow corporations to profit from human rights and environmental harm, because this cuts across the quid pro quo relationship we have between society and companies. The bigger question, though, is whether enterprise law should enable every member of society to realize their full potential, which was Principle 10 in the book. Now, while I have no problem in seeing a state obligation in this regard, I'm not sure as to whether corporate law as a type of enterprise law is really the right place to have society realize their full potential, given the economic focus of corporate law. And then so in that regard, I kind of join Professor Sorensen's comments as to whether all of the 10 principles should be applicable to all enterprises. Nevertheless, what I think that we can all agree upon is that all enterprises, whether they be corporations or the state, should not be limiting anyone's full potential. And I truly believe that Ewan's book is really a very strong first step towards recognizing that important fact. So thanks very much and congratulations, Ewan.
Thank you very much, Banali, for another very, very resounding endorsement and some really very important issues for us to consider. I will now call on Jerry to give your comments.
Yes, well, thank you very much for the opportunity to engage in this debate. And first of all, add my congratulations to you, Professor, for really focusing on this very, very important topic. And the fact that we all really do need to understand the bigger picture of enterprise law. And you clearly, an enormous amount of research and hard work has gone into this book, and I have taken the trouble to read most of it, and I do congratulate you on really all of your endeavour. I've been asked to look at this from a practical point of view, i.e. because I'm a company director, and first of all to talk about the changing role of directors. And where I would agree with you is that there is a crisis in board governance, and not just in business, but in the UK, in the NHS, in universities, in charities and sport. And also that the role of boards and directors is even more important now and demanding, given the range of challenges facing enterprises. And of course, you very eloquently describe a lot of those challenges. There is then, of course, the critical role of independent directors on boards. And boards are paying more attention to diversity of directors as it becomes even more important, since it's a key ingredient of board effectiveness. And then stakeholder governance, as compared simply to investor governance, is also receiving greater attention by boards. And lastly, regulators are paying more attention to issues such as ESG, and a good example would be the SEC requirements in the US. So that's kind of background in terms of the changing role of directors. Now, what then about the implications of your perspective? Well, first of all, yes, categorically agree, all is not well with the governance of boards of enterprises. I quote here from your book that directors' duties are frequently unenforced to the detriment of society, the environment, consumers, staff, as well as the true investors in capital. So yes, agree, there is a crisis in governance. And the issue, however, and again, no one can disagree with the laudable principles expressed in the book, but I would argue that improving the boards of enterprises is really about improving their effectiveness. And in that respect, we have enough rules, and really it's behaviour that needs to change. And I'll just quote here a list of the recent changes in the legal framework regarding enterprise governance. We have the Cadbury report, we then have the Greenbury report, the Hampel report, the Higgs report, the Walker report, and the revised UK Code of Corporate Governance. But when you look at board disasters, and I did some research by London Business School, which is described in our recent book on board disasters, we looked at 80 of these all around the world and effectively identified the types of board dysfunction that caused the board disasters. So the solutions are less about law and more about changing board culture, greater stakeholder engagement, and practical steps to improve board effectiveness, i.e. stronger independent directors. Then in your section on corporate constitution, you argued that the FRC is ineffective. And again, I quote, "It is doubtful that these independent criteria for independent directors achieve any real goal. The fact remains that independent directors work with other board members. They will be friendly and partial to one another's preferences. Directors usually appoint themselves. This unsatisfactory state of affairs reflects what is still a closed and cosy culture among boards." Well, I would like to see the evidence for these generalizations that you make, sir. You then argue that shareholders typically monopolize power. And this really ignores the increasing trend for greater stakeholder governance, which is a great trend that's happening now in companies, and ESG would be a classic instance of that. And then in your conclusion on labour, and again I quote, that the paucity in protecting the right to work, board representation, elected work councils with binding rights in management. But you appear not to take into account the really practical difficulties of how to select representatives and how they can really contribute to the running of large global enterprises. On the other hand, you don't mention equity sharing with the workforce. For example, the John Lewis Partnership, which in my opinion can be really effective. Others of your recommendations, I would argue, are impractical. Your comment on education conclusions, and I quote here, "First, to uphold international law, there's a need to progressively eliminate fees for education, particularly at universities." And I speak as a council member of the University of Exeter. the university sector is really, really struggling financially because fees have been fixed until 2024. So your proposal would be completely impractical. On the section on health, you argue that the NHS is politically untouchable because it works. Well, tell that to the 7 million people on NHS waiting lists. The NHS is not really working. The real issue is to do with the current mandate of the NHS, which is impossible to fulfill. Then in your section on military and security, again, I quote, the biggest question overhanging the military is how can it be eliminated as fast and securely as possible? So what, sir, do we do to defend our country? And how do we help Ukraine? You then, I think, in my opinion, promote the myth that public ownership is the panacea for many ills of enterprises. But again, I don't see any evidence being provided for that. In the theory part of the book, you argue the case for the principles that it seems obvious that some enterprises work best with private ownership, and other enterprises, it seems equally obvious, work best in public ownership. Again, where's the evidence for that conclusion? There are, of course, some excellent initiatives in the book. For example, and again I quote, the internet and the major tech companies that have colonized it need to be regulated. A very, very important area. But another area which I think you could have mentioned in terms of need for more regulation is the need for education and qualifications for company directors, which would make a great deal of difference in terms of governance. So one can argue I have maybe been critical of your book, sir, and indeed I have, but I wouldn't want that in any way to understate the prodigious amount of work which you've done, and also in focusing on the attention of this very important issue of the bigger picture of enterprise law. So congratulations, and I hope you won't take any of my comments personally.
Thank you, Jerry. I mean, the whole point of this is also to put Ewan on the spot in order to account for how he's come to his conclusions, as well as his agenda and his blueprint for how corporate law ought to move forward. So I'm just wondering, would you like to respond to any of the commentators' views first before I collect the Q&As and move on to a general question?
I'm entirely in your hands. I can respond quickly to the comments and then we go to Q&A.
Yeah, why don't we do that? Right, okay, yeah, over to you.
Thank you so much to all of you, and I really appreciate the time that you've taken to read through the book, because it's very long, and I'm impressed that you've all had the opportunity to read it so closely and hone in. I really like it how you've sort of honed in on different parts of it. Perhaps if I could take everyone's comments in reverse order. Beginning with you, Jerry, and I really appreciate the comments and the criticism that you've made. Could we go to the slides again?
Right, yeah, sure.
If you just share the screen with the slides again. So, Jerry, your last point was, well, what's the evidence? And I think if you just give me the mouse, Iris, then I can do it. There we go. You say, what is the evidence that public ownership is working well? For some reason, this chart is upside down. Oh, gosh.
If we click on this particular icon, would it?
Ah, there we go. Does that rotate it?
It's supposed to, I think. Oh,
I have no idea why that's rotating. It wasn't in my slides. So Jerry and everybody, what we can see here is, I didn't include it in my talk, but one of the things that I started doing, and one of the things that enterprise law allows us to do, is start mapping how enterprise laws work all around the world in different jurisdictions. So what you can see here, and I'm sorry that it's upside down, is the 18 richest and most equal countries in the world, ranked by the Inequality Adjusted Human Development Index, and the extent to which key sectors, media, banking, buses, water, energy, mail, rail, internet, health, and universities are publicly or privately owned. Basically, you've got a tick, which is green, if it's more than 40% public owned. You've got a red cross if it's privately owned, and if it's somewhere in the middle, you've got a yellow dash. And what you basically see, if you sort of start from Norway and go to the left, is you see that the richer countries have a greater incidence of public ownership in these core sectors. Now, that's not to say that it's always going to be the case that public ownership is better, but generally speaking, you have faster internet, you've got more electrified rail, you've got more renewable energy, you've got better water quality. Richer countries do better, and this is correlating with a higher degree of public ownership. So there is a lot of evidence to provide, and one of the things that enterprise law allows us to do is start having a framework for collecting empirical evidence. Jerry, I think that you've taken the parts that I've said about the military slightly out of context. It's actually Dwight Eisenhower's problem of how we could, in the future, eliminate the military consistently with security. You might remember that Eisenhower, the US president, also World War II commander in Europe, said that all money that goes to the military could be spent on schools or hospitals, and that this increased spending on the military is like hanging humanity on a cross of iron. So the chapter in the military is very conscious that we can't simply eliminate the military, and that's not good for security. And actually in the afterword, after I'd written that chapter, of course, Putin launched his criminal war on Ukraine. And of course, that makes any decision to decrease military spending when there is such a big threat absolutely insane. But so that there is a fundamental question about how you maintain security when we have such large militaries. So that's that point. On the NHS, of course, one of the things that the book provides is an explanation of which health services in which jurisdictions perform best. And since the NHS reforms in 2012, an increasing privatization, we have had massive increases in waiting lists, like you point to. This is entirely to do with the waste on private doctors, privatization of surgeries. This is what has given us, along with COVID, the big uptick in waiting lists. On university fees, we are just going to have to disagree about that one. It is an international human right, everybody, that higher education is tuition free. It's not true that tuition fees have been frozen. They are frozen for home students. They have been soaring for international students, way beyond inflation. And actually for home students, they've tripled since 2010. And the big problem that we've got is a problem of governance. I agree with what you said about governance. And the money, therefore, is not being spent wisely, going into fancy buildings and bureaucracy. The evidence on boards not necessarily performing well. I mean, you quoted the part from my book. You could have also quoted Theresa May, who said that independent directors are often chosen through personal preference and mates and closed networks, not through open competition. And that actually comes out in the Hampel report on corporate governance, which you pointed to, which said that at the time, 91% of independent directors were not chosen through an open advertised competition, but just through personal contacts. So if you want the evidence, it's there. But I really appreciate the criticism. And I think that you do make a really important point about the need to change behavior and board culture. I suppose I take the view that more stakeholder voice, and this is principle 3 of enterprise law, more stakeholder voice would drive the change in culture. Banali, thank you so much for your comments. Is corporate law the right place for realizing everybody's potential? Well, so obviously, and this goes to Carsten's comments. Yeah, I actually agree with both of you. It's not corporate law that you might want to do that, but it's a principle of enterprise law more widely than corporate law. And I suppose the idea is that, and I take the view that in fact the whole legal system should ultimately contribute to this higher goal, which I think is, as you rightly say, a goal of social justice. And for everybody else who's not familiar with it, the very last human right in the Universal Declaration, the Magna Carta of all humanity, Article 29, is the one that says that one of the duties of the state is to make sure that we can develop our potential and our capacities to the fullest. You quoted from Burley, the great New Dealer, who gave a similar meaning of social justice. And Carsten, yeah, I mean, the ESG stuff in the new directive is really fascinating. I think both Iris and I were a bit surprised to hear that the council is now talking about dropping Articles 25 and 26. Look, I don't think that all 10 principles are for company law. I share your view about that. I mean, so it might be for sector-specific regulation. But, you know, so for instance, the S part of ESG, I think that there's a very good case for making sure that labor law and company law combine. I've never taken the view that they should be separated. In Denmark, I think where you're from, if I'm right, it's all companies with over 25 staff have to have workers electing about a third of the board. So in all companies, there's a case for worker involvement. How you get environmental standards being protected through company law is an interesting question. I probably take the view that, you know, you can't put trees or, you know, NGOs for environmental groups on the board, but you could have directors' duties to decarbonize, and that would probably work just as well as external regulation. But yeah, there's an interesting debate to be had. Elizabeth, I just one thing to say, I'm so glad that you brought up the networks, platforms and utilities work by colleagues at Vanderbilt and Columbia. So for everybody, it turns out that in America, some scholars there were doing a very similar thing to enterprise law. They go into certain areas more deeply than I do, and they add on some, like, so they've got big chapters on post, on aeroplanes and flights, on search and operating systems. I've got stuff that they don't on housing, education, health, but our focuses are almost identical, because what they've done in the States is they used to have a study of regulated industries that tried to look for common principles but cut across all sectors. And they said, no, we need to look at each context, each sector of regulation, because then you get the full picture, the technological and historical picture as well. So yeah, thank you for bringing that up, and thank you for all your comments.
Right, thank you, Ewan. We have some questions that are submitted online, but I'd like to just give an opportunity to people here in the room to think about what you might like to ask. We're going into a general Q&A session till the end of this event, so please feel free to think about what you might want to ask while I look at what has been submitted online. Right, there are two very interesting questions, I think, from the top of my list on SMEs, and the concern, I think, from Marina is about how SMEs could take up the challenge of such an integrated view. And I think that there has been concern as well, I mean, voiced by Carsten, and even Elizabeth was talking about, you know, whether there might be points where you think that specialism and siloing actually might still work. And here, you know, SMEs could be, you know, a particular lens through which you might want to apply corporate law in a more enabling manner rather than a more regulated manner. But what is your take on that?
Great question. So this book is primarily about big enterprises and big organizations. It doesn't have to be. But small and medium-sized enterprises usually don't fare very well in the enterprises that I'm covering, right? Because, you know, you've got the big tech monopolies that crush competition. You've got rail, which, you know, is not prone to small enterprises. But the general law of enterprise is, you know, where we see small and medium businesses thriving. You know, so and I could have gone into that a lot more, things like restaurants or clothing manufacturers, or I don't know, brewers, or food production. So you have a framework of enterprise law that enables small and medium enterprises to thrive. I think that if you've got workable competition and a framework, then you should let them do what they want.
Right. Okay, great. Anyone in this room wants to raise a question? Don't be shy. He is very friendly. Right, as you are considering, there is an interesting question here from an anonymous attendee in terms of the dichotomy between public and private. I think from the question I can see that people do buy this integrated view about how enterprises should engage in mutually supportive relationships with society. And I think that is important. However, I mean, there is also a reason why we have, you know, a kind of private public dichotomy.
Yeah.
So are you kind of meshing it up too much? And is this too much to ask?
Yes. Thank you, anonymous attendee. That's a really great question. I've written a fair bit about how, like a lot of people, the public-private divide is not useful anymore. At the very best, I think that we can make a good case that there is a very large social space within or between the core private and the core public. So the core public might be the functions of the state, the legislature, the judiciary, the executive. The core private might be, well, I even hesitate to say, but a sales contract, to keep it very simple. But then there's this enormous social space where private and public intermingle. But my view is that all law is based on associations between people. All law is social. Everything from, you know, a simple contract to a complex polity or an international, transnational framework is all about human beings associating with one another with different rights and duties in different ways. And the enterprise is, on different kinds of enterprises, are just one form of association, like families, like polities, but, you know, those are the sort of three major groupings. And I can approach the problem in another way. So, I mean, there's a very long strand of theory that would argue that, you know, all of the private is actually public. You know, for instance, in any contract, there's three parties to a contract. There's party A, the seller, there's the buyer, and then there's the state, which ultimately enforces the contract on terms which it regards as fair, and it bans illegal contracts, or it restricts the scope that people have to agree. Yeah, I mean, I do think that, yeah, you can describe the public and the private as mutually supporting, or you can abandon the strict division between public and private and just see that the law is all social, all different kinds of associations with different kinds of functions being performed in different parts of the law. And in enterprise, that's my attempt to do the finance, governance, and the rights function.
Right, thank you. We have a question from Marvish Rani about some general principles first in order to make things practical. But I thought, I mean, you have offered 10 principles in your book.
Yeah.
So as far as I'm concerned, I mean, you've offered 10 general principles. So I'm not quite sure what requirements there are to make them practical. I'm just wondering whether or not the question might be directed towards whether the principles are too ideological rather than practical.
Yeah, look, here's the 10 principles. Sorry if I could just move that.
Oh, yeah, sure.
Thing over. Here's the 10 principles. Now, a lot of these are very, very simple and straightforward. But they're supposed to account for everything in enterprise law, so we don't need to go into detail. But if we take, you know, number 7, which Benali focused on, and I mentioned briefly, that environmental and human health should be improved and no harm allowed. I mean, this comes from John Stuart Mill on liberty, from all of environmental law, all of health and safety law. I mean, that is a hugely straightforward, intuitive and practical principle. Just don't hurt other people or their stuff. Don't pollute the environment. You've got other ones like, let's say, Principle 5, that an enterprising state or an entrepreneurial state, a concept that I'm sort of borrowing from another UCL professor called Mariana Mazzucato, who has an institute here at UCL, an economist, is that an enterprising state upholds social security and places the risks onto the broader shoulders. So, you know, this goes to how we organize welfare, how we organize insolvency law. You know, what we want to do with our social security system is make sure that everybody has the ability to innovate and do different things and not falling into the abyss when things go wrong. You know, insolvency law is hugely interesting in this way. In the 19th century, we used to lock people up if they went insolvent in debtor's prison. You know, so Charles Dickens' father was thrown into Marshalsea debt prison when he was a boy. And, you know, most of Dickens' books were about his awful traumatic experience with that. And, you know, traders all the time got thrown into prison. It was huge risk. And so people didn't take risks. And around the same time as they were phasing out debtors' prison, they introduced, Parliament introduced limited liability. And this was one of the biggest ways in which, you know, innovation was enabled to thrive. And then later on, we got the welfare state, so that, you know, if you went, you had a bankruptcy procedure, that was the first step. But then also, if you lost your job, you would be able to get national insurance or now universal credit. So, you know, underneath all of these principles are very practical ideas that, you know, require a lot more elaboration.
Right, thank you. Anyone from the floor? Ah, right. This gentleman.
Okay, so I don't really know how to explain this part. So I'm going to use like banks as an example. So I hope you remember the 2008 financial crisis with banks, and like how many banks went like bust and how governments had to bear the kind of brunt of that. So firstly, do you think that something could be done to kind of prevent the negative impacts, like the social impacts of that, were that to happen again?
Yeah.
And to kind of follow on from what you just said about like the limited liability, should we potentially increase liability for like big companies and big banks and stuff, so that if something like this does happen, it's not just simply like a slap on the wrist, or like, you know, that bank gets bought out, but you know, like SVB got bought out by HSBC and like nothing really happens? Should we like increase liability? Yeah.
Great question. So there's one theory from Joseph Schumpeter in Capitalism, Socialism and Democracy, that what we really want in a dynamic economy is a wave of creative destruction. So Schumpeter seemed to put forward the view that companies, even big companies, going solvent is actually a really good thing, because through destruction you get creativity. And this was part of what, to Schumpeter, provided the dynamism of capitalism. And you'll see exactly the same thing being argued right now in America, that we should have let Silicon Valley Bank go down, because otherwise, how are you going to encourage, through the risk of destitution and ruin, innovation in a thriving capitalist economy? Now, I don't share that view, because I think that the Wall Street crash and the South Sea bubble and the global bank crisis and collapse in 2007 and 8 was really bad and entirely avoidable. All of these things come from, I would hesitate to identify the causes as not enough ex post sanction. And in other words, not enough sort of penalties after the fact that things go wrong. I think that the causes are more to do with speculative bubbles growing up, because people are allowed to essentially do stupid things, like invest in a company's shares that is doing the slave trade in South America in the 1720s. That was the South Sea bubble, the world's first stock market crash. Isaac Newton lost lots of money. Everyone lost lots of money in that one, and it was doing, you know, awful things. The Wall Street crash was a crash created through over speculation in companies when there was no regulation of portfolios. So people bought, a patch of swamp in Florida, and they didn't get, this fantastic real estate that they were promised. They got an alligator or something in a swamp. Or the global financial crisis in 2007, 2008, people invested in subprime mortgage debt, which came from homes that people couldn't afford to repay mortgages on, because people were really struggling with 2 or 3 jobs, and then money lenders were raising interest rates to usurious rates. So you get speculative bubbles, and speculative bubbles come from the failure to ensure that markets are regulated fairly, disclosure rules in contracts and investment. So I think that's how you really stop the banking crashes. And was there a second part of your question that I didn't quite get to?
Okay, so like how in 2008 when the banks crashed, people going into poverty, like people couldn't afford like norms food. Is there any way that we could kind of avoid that were another crash to happen?
Yeah, I mean, the way that you avoid the social contagion from a big collapse is, number one, you have, like Principle 5, an effective social welfare state. Number two, you make sure that full employment is not dependent on the level of bank lending, so that government takes responsibility for full employment. Number three, you make sure that people can't be dismissed easily. I've written quite a lot about labour law, and you see, for instance, after the global financial crisis and after COVID, a huge spike in unemployment in America, where you've got what you call at-will employment. Anybody can be sacked for any reason at all, a good reason, a bad reason, or no reason at all. You see a pretty big spike in the UK, because we've got very, very low standards for unfair dismissal law. You've got to be given notice, you've got to be given a reason, small redundancy payment, but not very good. You see a very small spike with huge crashes in Germany, where an elected work council has the ability to veto dismissals unless they consider them to be socially justified. So having democratic control over workplace decision-making is really key to making sure that big crashes don't translate into social collapse.
Right, just one point on what you mentioned about SVB. I think the whole point of SVB being sold to HSBC is so that people experience continuity in accessing their accounts. I think I do give it to our central bank for having done as good a job as possible, but I think the reforms after the crisis have really tightened up. So if you are into, kind of unpacking all of the technical detail of what has been done in bank capital liquidity, resolution sort of regulation, over here, as well as in the EU, we have been really very serious about implementing the reforms. I mean, there are issues over the US that are different from ours, basically. Right.
Definitely.
Right. I think the gentleman in the corner, I will let you have the last question.
Well, first I must apologize, I don't speak very many comments, I'm just here.
No, don't worry.
What would you replace politicians with? Considering the government of the day has the monopoly of legislative government powers. And it only change from time to time, therefore the ideologies. What would you replace politicians with?
Okay, I'm not sure that I would replace all politicians. I might replace the current politicians in the government with another group. But politics is important, and we need accountability through the vote in politics. One of the big things I think that we're lacking in enterprise, though, is a more accountable and democratic economy. So we've got systems to elect who's on the board of directors, but usually it's directors who appoint other directors. The real investors of capital, so people who provide money through pension funds, or the people that provide their labor for enterprises, they should be getting a lot more voice in the way that the economy is running.
Some of them should go to different subjects. Why is it academics, they read history, that fail to highlight the things that matter?
Well, we can only do our best. There's a lot of history in this book, though. There's a lot of historical background.
Mark Twain said, don't let your story into good education.
Well, on that note.
On that note, yes. Right. No, I mean, we've had a wonderful discussion and we've come to the end of our time. There is actually still one remaining question from someone online, and I'll leave it to you to see whether or not you want to type something to her.
Okay.
But we would like to say a great thank you for everyone for staying till the end of it and making this an overrunning event. Thank you all for being here. Thank you to my panelists for your great reflections and for reading the book, which is a great magnum opus, as Benali has put it. So thank you all for being here. And we hope very much to see you at our next UCL Centre for Ethics and Law event. So it remains for me to wish everyone a very good evening.
And thank you for sharing.